us now our reporter Shubhajit Sengupta from the Supreme Court. We've also got a panel of guests joining us. Karnika Seth, a cyber lawyer. We've got Rajiv Chandrasekhar, Rajya Sabha MP from Bengaluru, one of the petitioners. We've also got Sunil Abraham, Executive Director, Centre for Internet and Society. We're going to go over to our guests in just a second. But Shubhajit, just quickly take us through an overview of what the Supreme Court had to say.
The Supreme Court was clear in this case that 66A was a violation of freedom of speech. This petition had come in after the Palghat incident where two girls were arrested after peaceful protesting against the strike which was called in when Balasaheb Thackeray died. After that, it was in 2012. This case went on for 2.5 years. During this entire period, a number of other NGOs and the advocates who joined in, they filed their own petition challenging 66A, and finally today the court took the view of the fact that this is a law which is in violation with the freedom of speech. The government's view was also taken in. Government during its own argument had said that this was something which was seen to be as a necessary evil and they are not in favor of clamping down on freedom of speech. Today, after the verdict was declared, both the government and the opposition has welcomed it. Government says this is a victory for freedom of speech and they have enough provisions within the IPC itself to take care of anybody who misuses these mediums to take any kind of wrong decisions or to propagate messages of hate or anything else. And 66A, which is seen to be a very arbitrary law, is not needed, and hence the clamping down of 66A is something which has been welcomed by all sections, it seems.
Let's go back to our panelists now and really get a legal perspective on what this means. We've got Karnika Seth, a specialist in cyber law, also with us. Karnika, if we take a look at what the Supreme Court has said today, basically what it came down to was whether this section contravened freedom to expression or not. And the Supreme Court decided clearly it did, and therefore it was unconstitutional.
Correct. In my view also, when you look at the section, the terms were itself so ambiguous. Terms like inconvenience or annoyance, you cannot criminalize somebody and say, an act of annoyance could lead to, say, 3 years of imprisonment term, unless the gravity is there. I mean, you have to define the scope and determine the degree of a particular act to say that this act can be criminalized. Therefore, the ambiguity had to be, just struck down, and the whole section is quite vague. And that's the reason that I think that today's verdict, I completely agree with the stand and the decision. And definitely, when it comes freedom of speech on the net, is something that nobody would, look up and say that this is correct. Right. So, in order to grow, in order to let the free speech prevail, this was essential. So I think this is completely agreeable. Right,
let's go over to Sunil Abraham as well. Sunil, what this does is really bring up... Right, sorry, do continue. Let's go over to...
I was saying that when you see IPC,
yes.
You have various sections. You have various sections of the IPC where you have murder and other sections which clearly say what amounts to murder, what are the illustrations which will be there, and in this particular section, if you see section 66A, you would not find any examples or any illustrations to define the scope of these words. Therefore, right. This I would say that this was unconstitutional.
Let's go back now to a panel of guests. We've got Karnika Seth, a lawyer specialist in cyber law, and we've got Sunil Abraham, Executive Director, Centre for Internet and Society, with us. Sunil, I'm going to go back to you and pick up where the conversation dropped off, which was whether there are needs to define the Internet or not when legislating specifically for the Internet, whether there's a need to legislate specifically for the Internet, the larger discourse surrounding this particular section, and of course the Supreme Court decision on it. Some of the questions which have been raised, or which were raised in the petitions which had been put in as far as the Supreme Court is concerned, is what constitutes public and private space as far as the Internet is concerned. Don't you think that's at least something that needs to be addressed?
Is the question addressed to me?
Okay, we'll get back to Sunil in just a sec. Karnika, yes. Let me put the same question to you. What would your take be on it?
Well, I think internet is a borderless space, and it needs a treatment of its own kind. We cannot, use the general law which we use for every act to call it an offence. Would equally apply in all cases to internet or in the same degree, because you see, defamation online will have a far greater impact. So if it is really defamation, then what we have in the IPC and what we have in the IT Act should differ in terms of stringent punishments. Well, you have to basically see the degree. It will vary on the internet. At the same time, what you are expressing as an opinion or what you are saying in a consumer forum, maybe a blog, Karnika, say about a service provider or his goods or services,
let me ask you to elaborate.
It's completely justified.
Let me ask you to elaborate on that statement as well. If you're talking, and it's come up, but as far as Section 66A is concerned,
what I mean is,
is the fact that whether reblogs, retweets, sharing,
as far as
whether those are also factors.
Well, if there is something which is, for example, in terms of obscenity, we say that if something is obscene, then publishing something as well as sending or transmitting is also by somebody knowingly is also equally criminal act. Then
Right.
in the same way, if you say that if something is illegal, something is objectionable in the real sense of the word objectionable, then if somebody knowingly or willfully does the same act, will amount to a criminal act. However, the scope has to be defined, the gravity of the offence has to be very clear before you really impute that kind of criminality on an act. So that's what I mean. In the sense that if you're walking on the road, you cannot just walk with a stick and expect that you have the freedom. At the same time, you hit somebody. So you have to have a boundary where you say that yes, this is legal and this is illegal.
I'm sorry, we are out of time.
You can express your view.